Yes, so by way of introduction, hello. For those of you who don't know me, my name's Sophie Walmsley. I'm a barrister in the personal injury and clinical negligence team. And also joining today and doing the talk is Manon Rowlands, who you'll also be able to see on screen. And she is also a member of the personal injury and clinical negligence team. So of course today we're going to be talking about the updates to the Highway Code and the potential impact that we may see in litigation, particularly in terms of liability and contributory negligence. This is by no means a comprehensive review of the changes to the rules, but it is an overview of what we consider are the most significant changes and how we may see those develop. So without further ado,
yes, good morning, everyone. As we said, this is intended to be an overview of what we've seen, what we see to be the main changes that we're going to see in terms of our area of practice arising out of the changes to the Highway Code. Of course, the legislation underpinning the Highway Code remains unchanged. It's still not anything to do with strict liability, and breach doesn't prove liability and absence doesn't absolve. But of course, sorry, I had a feedback there. The Highway Code, of course, just remains relevant to the question of negligence, and a long-standing, well, at least it was identified in Butcher by the Court of Appeal in 2011 that breach may be evidence of negligence, but of course it always depends on the circumstances of the act committed, and that's probably the most succinct way of identifying the relevance of the Highway Code, of course, to our area of practice. The changes are aimed at improving safety of all road users, but particularly the more vulnerable road users such as cyclists and pedestrians. And that takes me really to the first issue we're going to discuss, which is the hierarchy of road users. And we're also going to be looking at specifically pedestrian use of pavements and perhaps the impact that might have on new things that we're seeing in the area, such as scooters. And we're also going to be looking at pedestrian priority when crossing, and also the impact of the Highway Code on cyclists, probably the two most widely reported issues we've seen in the media.
And we'll also give some examples of what we might see in the way that the new rules or the amended rules may be applied, and specifically regarding, again, those issues of liability and contributory negligence, and in fact, whether these changes are going to have a significant impact in practice. So those of you who probably had a good look at the new Highway Code, what we've really seen is three entirely new rules set out at the outset of the new version, and they're identified as Rule H1, H2, H3, and those are sort of general wide-ranging commentary, we would say, and then those are of course supplemented by around 30 rule amendments to specific rules already existing in the old Highway Code. So the first rule, H1, really looks at the hierarchy of road users, and of course this isn't at all a new principle to road traffic accidents. It's really always been the case that, generally speaking, a greater level of responsibility is imposed on those who can do the greatest level of harm. It was discussed, well, the most well-known example is probably Eagle and Chambers, where Lady Justice Hale, as she then was, discussed how it's always been the case that there is a hierarchy of road users, and a higher burden is usually imposed on car users as opposed to, for example, cyclists and pedestrians. And the wording used in that case, of course, was cars can always be a potentially dangerous weapon. So, you know, that case just really illustrates the fact that for over 20 years, we've seen that there is a hierarchy of road users. But what we see in the amendments of the Highway Code and this new rule H1 is that fact that's always been set out in the authorities that we use is now being codified into the Highway Code. And we're going to discuss in quite a bit of detail in the case summaries that we're going to be looking at how we think that might impact litigation going forward.
And the next sort of change that we see is in relation to pavements. And again, we see a codification of what was essentially already existing in practice, which is the rule that only pedestrians may use the pavement. There is an exclusion, obviously, for wheelchair and mobility scooter users. That's pretty sort of standard. There's an absence of any reference to different sort of scooters, such as electric scooters, which we'll come on to in due course, but also of note is the fact that the Highway Code now also explicitly allows pedestrians to use cycle tracks, and again quite significant is that the cyclist should give way to those pedestrians in those. Again, it was a degree of common sense before, but is now mentioned explicitly within the Highway Code as to the priorities that each party should have. And again, the added emphasis that the pedestrian should take care not to pose as an obstruction and to remain aware of their environment and avoid unnecessary distractions. So whilst it may seem pretty obvious to many, particularly when considering these potential sort of claims, it's now again clearly set out in the respective duties of each party in those scenarios. We see the cyclist bearing the higher burden following that hierarchy of the road users, particularly the more vulnerable. And it's nothing that is particularly new, but is formalised. And we see various changes to rules for cyclists, and we've identified a couple on the slide there. So Rule 62 and 63, which mention about this interface with cycle tracks and cycle lanes, and sharing that space with pedestrians and horse riders and horse-drawn carriages, etc.
And this question of pedestrian priority, of course, is extended out into priority when actually using the roads. And this is perhaps one of the more widely reported changes to the Highway Code, again at Rule H2, but it's also set out specifically in Rule 170 and 206 that we've put up there for you, which is the change from drivers having to simply watch out for pedestrians and only give way in circumstances where a pedestrian is already crossing a road. You'll see in that first paragraph on the slide, the Rule H2, and as I said now, Rule 170 and 206 again emphasise that at a junction, you need to give way to pedestrians crossing or also waiting to cross a road into which or from which you are turning. This is going to be one of the cases that we're looking at, how this rule change might impact litigation going forward. But it goes without saying that it's a significant change to having to actually give way as opposed to having to watch out for, and also to have to give way to pedestrians waiting to cross, as opposed to those who are already simply on the crossing. This rule is slightly tempered by Rule 8, which applies to pedestrians and says that pedestrians are now required to cross where drivers can see you. So it remains to be seen how those two rules kind of work together in terms of how we find liability being apportioned in cases where perhaps people are waiting to cross where there isn't very good visibility.
And now turning to where we've seen quite a number of changes between the previous version of the Highway Code and the new updated version. There are a lot more explicit rules as they relate to cyclists and things about their positioning, riding two abreast, space that cars should give cyclists when they're overtaking. And again, this is something which has attracted outcry from the general public and has been very much publicised by the media in terms of the new obligations that cars are to give cyclists at certain junctions. Again, probably a matter of common sense in the past, but if a cyclist is now intending to go straight on and a car is waiting to turn at a junction, again, the car is essentially to hold back and to let them continue before making that turn. So it sets out again quite clearly how that hierarchy of road users is coming into play, with the cyclist in those circumstances being given essentially precedence in those specific circumstances. We've got the rules that we've spoken about in terms of cycle lanes and cycle tracks and the interface with pedestrians and other road users. But what we see is a development on where we were at previously. So we've now got explicit guidance on safe passing distances, for example. So vehicles overtaking cyclists or horse riders, etc., we're always told to leave enough room, but we're never really told what that might actually entail. But now we have a distance, and it's explicitly set out at least 1.5 meters when overtaking people cycling, if you're traveling at a speed of up to 30 miles an hour, and perhaps even a greater distance if you're traveling in excess of that speed. And a similar distance is now specified for overtaking people riding horses, for example. So that's set out at being around 2 meters, particularly even a foot low speed. And again, the onus still remains on the driver to make sure that they're only overtaking when it's safe, and when they can make that clearance. But where we've seen some controversy, particularly in the media, and which we'll come on to in our case studies, is the positioning of cyclists and what they can do. So some of those rules now dictate that cyclists are able to travel in the centre of a lane where it's safe for them to do so, but in busier routes, again, the onus might still be for them to be slightly off to the side. And we see explicit permission almost for them to ride to abreast. I mean, it was always quite common practice that in some circumstances it may very well be safer for cyclists to travel that way, but essentially the highway code has taken the argument out of it and has quite clearly set out that they are able to position themselves in such a way, and in fact it is the preferred way for them in certain circumstances. So we've got their road positioning, which we'll come on to in due course, and various amendments to some of the rules that were already in existence. So we've got Rule 67, for example, which is in respect of turning, and Rule 76. So again, much of what I suppose was already in existence has now been formally put into the highway code, and we finally have some of the clarification, which I think was missing in quite a lot of the previous guidance that was given.
So those are really the 4 areas that we've identified that we're going to see changes in the way perhaps litigation is conducted, in the way that cases end up playing out in court. What's absent from the highway code is any reference at all to e-scooters and how they should be used. We referred to kind of pedestrian priority on pavements, and now the explicit mention in Rule H2 that only pedestrians can use pavement, but anyone at least who's been around Bristol will be fully aware that scooters are regularly used on pavements, and that's going to be interesting, I think, to see how they play out, because of course e-scooters have inbuilt insurance, and so we're going to have to just wait and see as to whether we see increased claims in that respect between scooters and pedestrians. We also have to think about how e-scooters are going to fit into the hierarchy of road users as well, in relation to when they're properly using the roads.
Yes, and that's quite a key question as to where they would fit in. I mean, logically, one might think that they'd probably be considered comparable to a cyclist or perhaps like an e-bike. They are, in essence, a vulnerable road user in much the same way. They are more difficult to see, they're less protected, particularly if one thinks about potentially the impact between a car and an e-scooter, which unfortunately we've seen some cases like that. The speeds are again capped to a sort of similar level as e-bikes, but e-scooters aren't made uniformly, and we see this in some of the pilot schemes that have been advanced. Different areas have sort of a different prominence of different companies, and the e-scooters do vary from place to place. And so whilst one might automatically think that they would be a vulnerable road user, it's not entirely clear how that's going to play out with the highway code. And for example, who should be giving priority and in what circumstances. So would a rider of an e-scooter have the same precedence, I suppose, at a junction that a cyclist would if they were intending to head straight on? Or would that be different? It's not made particularly clear. And the general sort of interface between the highway code and the regulations and e-scooters isn't very well established as yet. They're still relatively new. For example, the new small claims portal, it allows more vulnerable road users to drop out of that portal, and again, not explicit as to whether e-scooters would come in under that. But what we do know from the data that's been gathered so far, as at June 2021, was that there was over 880 accidents which involved e-scooters, and some of those involved with collisions. So it is an area which is going to be of prevalence and importance, particularly as we start to see e-scooters perhaps become a more permanent feature on our roads. And the Department for Transport has also indicated figures that show that, unfortunately, quite a significant number of those 882 accidents involved quite serious injuries. So clearly there is a need here for more regulation and an expansion and an explanation as to where these sorts of electric vehicles or are going to fit within the current existing framework. We know that the current trials were extended until the end of this year, and presumably that's to allow the government sufficient time to develop those regulations that are in place and find a way for e-scooters to exist harmoniously within the current framework. But I think it's likely that if they do become a permanent feature, we may ultimately need to see further revisions to the highway code to cover these forms of electric transport and to essentially account for these sorts of riders in that hierarchy and setting out in what circumstances they would have precedence. It seems clear from the existing rules that, for example, they're not for permitted use on pavement, which could cause some friction, some problems, because I, in my own sort of experience, have seen these sort of riding on pavements in certain areas. So definitely an area of further development and something that will need to be covered in greater detail if these are going to become a more permanent feature on our roads.
Yeah, and I think whilst we're just on that point, we've had a question posed in our chat box, which is essentially asking, well, do e-scooters count as scooters in the sense of the H2 rule on scooters being used by pedestrians, and also whether does an e-scooter basically get counted as being the same vulnerability as a cyclist, or is there one way or another? And I think that's what the difficulty is because the highway code is entirely silent on it. I think we're probably going to have to wait a little while until we have a court judgment to actually decide that point, and using the best of our abilities, as Sophie's identified, and to an extent they're mechanically powered, or powered by electricity. So you would think that it would be closer to perhaps a motorcycle rather than a cyclist, in the sense of being less vulnerable, even though we know that more generally they don't use things like helmets. So I think really it remains to be seen, and we're going to have to wait quite a while probably to find out where they fit in that hierarchy, and because they're just not referred to at all in the new highway code, unfortunately.
Yes, and quite a sort of an interesting question that I saw in the chat generally is about whether the e-scooter to a cyclist, whether they're more vulnerable if there's no helmet. So the regulations at the moment, I think, encourage the use of a helmet, but similarly, they're not required, like they're not required for bikes. There may be a question of contrib, obviously, as we see in the current case law anyway. But I think they are far more exposed to the elements, I suppose, and as Critty's identified in the chat, they don't take the impact in the same way that a bike might take an impact. And so these are all things that will need to be factored in when we're considering, to what extent other road users should essentially give priority and precedence and adapt themselves to e-scooters. And also, rather crucially, imposing responsibilities on riders of e-scooters. I mean, we've seen them driven in various different ways. There have been numerous studies which have indicated that, unfortunately, it does seem to be the younger population who seems to be the larger share of those accidents. So whether there needs to be more education for those because you only need a provisional license to use them, about the highway code and about what riders should be doing and the precedence that they should be affording different road users to make it safe not only for e-scooter riders but also for other road users. So moving on, we're now going to look at a few of the new rules in the context of examples of cases that I think we've all seen or are likely to see. And one of those is, as we can see here, with the new rule about pedestrians having essentially a priority at junctions where cars are now expected to give way to them if they are crossing or waiting to cross. And we can see, again, the reference to the new rules, so the new rule H2, and also the importance of rule 170. And that distinction of giving way. Now, it's not an absolute, there's no must in there, like there is in other provisions of the highway code. It is that you should give way, but it is still likely to be very indicative of where we see cases heading, given that there is now essentially a positive obligation imposed on drivers to make sure that they are giving way to pedestrians that they can see. Whereas previously, whilst we know that cars should have stopped or slowed if there was a pedestrian already crossing the carriageway, it sets it out in a way that sets quite clearly a level of precedence, in my view, as to what the car should be doing, and again reflects the fact that pedestrians in the circumstances, they're less likely to be able to sort of appreciate a vehicle that may be coming at speed. For example, we know that vehicles can turn up very quickly. If they're looking in multiple directions, they may not necessarily have seen the vehicle approaching and thought that it was clear to pass. So in some ways, it does make sense that they are protected in that way. But it also adds a different onus on drivers. Whereas before, they were always encouraged to slow down on approach to junctions anyway, but now that's almost increased in a way. We may very well see different types of accidents where riders or drivers who are coming down approaching a junction may not necessarily have had the best visibility or have spotted the pedestrian perhaps just a little too late, and then suddenly have to come to a stop or suddenly slow down, which may eventually cause a collision with the car from behind them. We may see accidents arising in different circumstances as people try to familiarise themselves and get accustomed to these new rule changes. And where we also might see an impact is where we end up to with any reductions for contributory negligence. Now, there's 3 cases that have been put upon the slides there, which are quite well known, where pedestrians have either walked across the road or stepped into the carriageway thinking that they've had enough time. And in most of the, well, in all of those quoted there were reductions for contributory negligence. Now, it may very well be that we see lower reductions for contributory negligence than we've seen previously because of this now increased duty for cars to give way in those circumstances, or possibly in some circumstances no liability at all. It will be something that I imagine will develop quite quickly, but we'll see it develop through the courts. That, as I say, now that there is this increased duty on drivers to make sure that they are, you know, even stopping and slowing down if there's somebody waiting to cross, that it may very well reduce liability for pedestrians going forward, particularly those who have stepped out and walking across a junction.
And we know also, we discussed previously, just on that point though, the amendments to Rule 8 about the requirement to actually cross where drivers can see you. So as Sophie said, it remains to be seen really there's a balance between those two things. It seems quite clear that the burden seems to be shifted over quite heavily onto the drivers in that sense, but it is slightly fettered by Rule 8, which also does now for the first time ask pedestrians crossing to cross where drivers can actually see them. The second example that we thought might be useful to look at is that of car doors opening out into the paths of cyclists. Unfortunately, we all know that these incidents are relatively commonplace. All the sources seem to suggest that we've got upwards of at least 500 cyclists a year injured in this way, and around 60 deaths a year. So it's by no means an uncommon accident that we see in road traffic litigation. Now, we know, of course, that actually to open out a door from a parked car into the pathway of any person is actually an offence. It's contained in the Road Vehicles Act regulations. Sorry, the 1986 regs, and it carries with it a fine of up to £1,000. It's obviously something that we see a lot in the news. It's a highly charged thing for that purpose, but what we've seen historically, and maybe one of the earlier cases to look at is the case of Burridge and Airwork. What we saw in that case was effectively the Court of Appeal deciding that the cyclist couldn't be held to blame for driving into collision with an open parked car door, and the Court of Appeal actually went further and rejected any kind of arguments that cyclists should be held contributory negligence in most cases for driving too close to those parked cars. So historically, that's what the case law has established in relation to these kinds of accidents. But now there's quite a stark amendment to Rule 67 of the Highway Code that applies to cyclists, and it adds that cyclists need to take care when passing parked vehicles, leaving enough room, a door's width for 1 metre, to avoid being hit by a car door if opened. And it also has the provision for watching out for pedestrians in the same way. So, of course, it's difficult to see how we won't see an increase now in findings of contributory negligence against cyclists in these kinds of accidents, where Rule 67 specifically says that they're required to leave enough room. Again, it isn't a must requirement, as we've seen elsewhere in the Highway Code, but it's quite clear that what they're being told to do is to leave enough room, a car's width or 1 metre. Now, the thrust of that amendment, as I said, is that surely we're going to see an increase in contrib at least being argued, if not found, against cyclists. Again, slightly tempered by Rule 239, potentially, what's known as requiring drivers to use a Dutch opening to open their car doors, and namely using your other hand to look over to ensure that you're looking out behind you before opening out the door. So again, this rule is a slightly weaker rule, and it's a recommendation, but it's a recommendation which says where possible, or if it's safe to do so, do it this way. So it's a less strong a recommendation than Rule 67 if you're going to compare the two, and I don't think it's going to go very far in reducing the efficacy of Rule 67 that we see there.
And then our final example is this case, which some of you may have seen around on the internet or circulating around, which concerned a man who was riding on his bike in the centre of a carriageway on a busy London street, while simultaneously videoing himself and taking selfies on his phone, much to the annoyance of the vehicle behind him. And the suggestion, as you'll see from that heading, that title used by this reporter, is that it was almost sort of carte blanche for the cyclist to do what he pleases, and that isn't quite the position. It wasn't the position beforehand, and it isn't the position now. So what we're looking at here is, as we mentioned before, Rule 72 now goes further than the previous version of the Highway Code about cyclists' positioning. And in particular, what it does say is that there are two basic road positions that can be taken. So the first is riding in the centre of the lane to make yourself as clearly visible as possible, but caveats that with some certain situations. So, for example, on quiet roads or streets, or in slower moving traffic, or at approach to junction or road narrowings where it would be unsafe for a driver to overtake. The second set of circumstances is probably what would be most relevant here, is when riding on busy roads with vehicles moving faster than you, allow them to overtake when it's safe to do so, and keeping at least half a meter's distance from the curb edge. So again, we see that sort of road positioning. In these circumstances, it could be argued that he shouldn't quite be in the centre of the carriageway, although from the photo we know that car probably wouldn't have been able to overtake at that point in time anyway. So we've got more detail on road positioning, which could have impacted where we can see that individual on that photograph. The second issue is the use of mobile phones. So there's no explicit provision as it relates to cyclists. There is Rule 149, which talks more generally about use of mobile phones or other types of technology in the car. It's odd that they've not gone far enough to impose that rule again on cyclists and other road users, but it probably does in practice, and in any event it probably falls within those other two rules that are quoted on that slide. So Rule 66, which is avoid any action that could reduce the control of your cycle, and also Rule 68, which is you mustn't ride in a dangerous, careless or inconsiderate manner, which one could quite clearly consider using your phone to take selfies as being dangerous, careless and or considerate in the circumstances. And so really, this example goes to show that whilst there have been some changes in respect to the substance of the highway code, particularly as it relates to pedestrians, there are some instances where actually the same behaviour would have been prohibited under the previous rules in any event. It's just that the current ones go a little bit further. It isn't, in essence, a carte blanche for cyclists to do as they please, as has been portrayed in some media stories, and as is a representation, I think, some members of the public have. The rules essentially are as they were in practice. They've now just been codified and made clear and abundantly clear in the highway code.
So it's quite difficult to provide a summary of all these rules, as we said, and we're always at risk of giving quite polarising views, like what we've been saying we see in the media, and that we don't necessarily agree with that, and that it is, of course, very nuanced, and every individual circumstance of an accident, there's going to be however many rules that you need to look at to determine liability in that case, of course. But just to give our broad takeaway from this, really, is while there's additional precautions for all road users, really the winners under the 2022 amendments are pedestrians. There's very few new requirements for them to comply with, and they're not very onerous at all. On the other hand, we have seen increased burdens on both cyclists and drivers. Hopefully, by going through those case summaries, you will see how we expect those kinds of changes to play out in reality.
One of the other issues that sort of have been identified is the lack of familiarity with the new and updated rules, both in terms of the general public at the moment and also in terms of practitioners, which we'll come on to. There was an interesting survey that was done by the AA shortly before the introduction of these rules at the end of January 2022, which revealed that a third of them were still not aware at that time of the changes, and actually 4% of the over 13,000 people that they had canvassed as part of this survey wouldn't be reading them. And we've also seen stories in the media of motorists who really disagree with the rules, particularly those about cyclists and giving way to pedestrians at junctions. So at the moment, we're still in a scenario where motorists may still be confused about their obligations. And in fact, I saw a news story relatively recently where they'd been waiting at a junction and most of the drivers didn't in fact give way to the pedestrian. So there will inevitably be a period of time for this to sort of become more commonplace and become second nature to drivers. Obviously no excuse for them not being familiar with those rules. They should be, and they should be abiding by them, and that would be relevant in terms of any litigation. There's also probably going to be a question as to whether these amendments should be looked at retrospectively, and I think Manon wanted to talk to you a little bit more about that.
Well, yeah, there's going to be a question mark. We talked about the confusion for actual road users, but it's probably also going to lead to a bit of confusion in terms of how these cases need to be pleaded, because of course what rules are supposed to identify as safe practices when you're using the road. So there is going to be a question mark over in the runoff period from, say, accidents prior to 22, what rules you should be looking at. Now, you'd expect, of course, for practitioners to utilise rules that were in force at that time, but there certainly isn't a rule telling them that they have to do that. And so we're going to have to wait and see what happens in terms of how the cases are pleaded, and it's probably going to be quite an unattractive argument to respond if you do face allegations of having breached the 2022 rules prior to that date. It's going to be a very unattractive argument to say, well, you know, I wasn't negligent prior to 2022. Maybe if I did the same thing now, I would be. So I think we're just again going to have to wait and see how that plays out. Hopefully, it will be quite a short runoff period before we move into the 22. The 22 highway code being used full time.
Ultimately, I think where we get to is that these changes are essentially designed to formalise what should have been common practice on the roads and common courtesy on the roads anyway. It's just trying to increase that level of safety, particularly for those who are most vulnerable, so looking at the pedestrians, looking at cyclists, and it is very much with those aims in mind that we've seen the development of the rules in the way that we have, and there's no reason to suggest that we're not going to see the same logic then borne out in case law. Not to say that it hasn't done previously, because we are aware, of course, that there was always an increased obligation, given that cars were often likened to more of a dangerous sort of weapon type of thing compared to a pedestrian walking across the street. So it essentially formalises quite a lot of what we'd already seen, or what we already should have seen. But that being said, there are some quite key substantial changes which we do need to bear in mind. So specific obligations, changes at roundabouts, for example, in terms of cyclists and perhaps even horse riders, etc., being able to use the left lane to continue straight on, seeing the way that those obligations are formalised at junctions, so you know, not cutting into the junction if there is a cyclist wanting to carry straight on, giving way at junctions. There are a few things that I think both practitioners and the general public need to get their head around in terms of what they are now required to do, or what they should be doing. And it's just that those are now made clear, and as I say, we'll see that develop over time. But I don't think, in my view, most of these rules don't really come as that much of a surprise, and just formalise what we've already seen, plus making some extra sort of suggestions and recommendations for what a reasonably competent driver would be doing in those situations. So we've come to the end of what we wanted to talk about. Are there any questions that any of you in the chat want us to address, or any points of discussion that you would like to raise?
I think maybe we've answered some of the questions as we've gone along, which might explain why we don't have any questions coming up now.
Well, we won't keep you from the rest of your morning. We just wanted to thank all of you for joining us today. The slides will be circulated in any event, and this webinar has been recorded, so should be available to you all anyway. But again, thank you for joining us. If there are any questions, we will be waiting around for a little while, for a few minutes, and we can address those. Also, James Bentley has made a great point in the comments about using and linking the new rules as essentially a codification of older standards, which is what I would quite expect to see. Is, you know, this is what motorists should already have been using. It's just now been made clear. So thank you, everybody, and I hope you have a brilliant rest of your day.